immediate treatment, etc. But in actual, the insured person feels cheated when he goes to hospitals for treatment and is not recommended by the insurance agencies on the basis of pre-existing disease. The man is half gone when he does not have money not recommended by insurance agencies for treatment. This also amounts to medical negligence. Then the medical negligence starts at the level of doctor, nursing homes, hospitals. There are no proper labs or tests which could describe your disease at one go. And you are subjected to various tests which involves money, that writing of health due to blood and other tests. But some doctors get it done unnecessarily to have their cuts and name and resources. This is a very bad situation in our country, preferably in India, not in USA. It takes a hell of time and money for the patient, and he feels himself of that. Some persons like me who can manage also fear to go to hospitals for such a cumbersome process, and they don't go to hospitals. Recently, I was walking around near the IMH hospitals. I told them I had some heart problem, something like that, and I told them I am an advocate in the Supreme Court. 4 doctors surrounded me, but I saw a person's common man, he was not being treated properly. So this is the situation, resources and other things being found in the AIMS and other hospitals also. We have recently seen in newspapers and news items in media that last week a child's tongue was cut instead of legs. Someone's hands were amputated by mistake. Some long operations, etc. took place. That is also a gross medical negligence, playing directly with the life of a human being. Why it happened and why it happens? Is a doctor not fit to treat? Is he less educated or not given proper perks to keep himself fit, to keep his mind towards the profession, or doing intentionally or on the saying of others to spoil the name of the institutions where he is working because he wants to go at a higher box in some other institutions? Or he is dissatisfied from his own family life and not providing proper attention to his profession. This is also medical negligence. What is the remedy for this? We need proper medical negligence laws. Recently, government approved medical board constituted by doctors under IMA to find that medical negligence, which is gross violation of the rules as per the Constitution. How a board of doctors constituted can go against a doctor who has done wrong thing against him. So we have in our profession also, in legal profession also, some doctors have come after doing some law and other courses. So why don't we have those doctors, doctor advocates, as in the name of those board members, instead of having the doctors directly to go for the cause itself? There is a need to put persons from the advocate community and judicial officers to conduct the inquiry, as many medical professionals have also entered the legal profession and can also be helpful to conduct proper inquiry. We have seen in Nithali case that is going on in Noida, Malushi murder case of Noida, that doctors changed the samples, DNA tests were required to be done again, whereas the case was under top CBI agency. Our organization, with the help of Dr. Anish Agarwal, can pursue such cases in a better way if we are given a chance. So where is the honesty and the proper treatment? This is also a gross medical negligence. The great reason for medical negligence is that decisions are not quick. The decisions are taken with not heavy penalty or license cancellation or longer term convictions to medical professionals or authorities. Whereas the treatment charges have now equal or even more in some cases as compared to USA and other countries, but convictions not comparable. In USA, a great debate and issue is going on, healthcare, to provide healthcare to all in public option system, which is also being opposed by some senators. 2 committees in USA have already approved it, those committees have already approved it. But the other committees, because of the political reasons, they have not approved it yet. The Senator Committee is going to have the debate on this issue next month, in December itself. So let us see what happens over there. A doctor can be sued for even a small negligence, maybe a lab fault, respiratory fault, also for a minimum of $1 million. In some cases, so they also get insured heavily to charge heavily for treatment, but the decisions are quick and implemented in a time-based manner. Insurance agencies now don't want the bill to be passed over there because they lose heavily, but at least in India we can go for strict implementation and quick decisions and heavy penalty so that medical negligences cases can be reduced. In France, the medical healthcare system is better than other countries. Even a tourist gets medical treatment for a minor amount and no major court cases because when you get proper treatment at low cost, you ignore many things. Whereas in India we see a lot of masses, less doctors in hospitals, deficiencies, long prescriptions and wrong operations. But people, even after being cheated, do not come to authorities, not go to courts, because they feel that they will not get proper justice and even lose what they have. There is a need for proper implementation of our laws and bring more strictness for common people. Recently, our health minister, Mr. Ghulam Nabi Azad, has announced that they are going to open 6 AIMS in Jodhpur, Kashmir somewhere, and six are going to be operated by 2012. He has also announced some award of 12 crores who is going to have it in the first instance. If such kind of things are happened, we don't need the proper, not only proper aims, but the proper doctors also. Because if the aims are there, doctors are not there, there is no treatment. Medical negligence will always happen. We have to pay them properly, and there should be some essential, something of that sort there so that they could not go on strike. We see that 4 or 5 persons are sitting on the bed itself and doctors immediately go on strike, nurses immediately go on strike. What is the use of that aims or hospitals when the doctors go on strike? So medical negligence also comes over there. We should have strict implementation of our laws and our court should come forward in such cases so that doctors could not go on strike or there should be some proper treatment for the persons who are admitted in the hospital. So medical negligence laws have to be changed properly, not as per the India, but implementation should be as per the basis of the USA, France and other countries, so that if doctors who are not properly doing their duties, they could be punished heavily and they don't do anything wrong with the common man, or they don't go with the nursing hospitals or nothing. I have seen that the doctors who are working in the morning hours in the hospital are not likely they are doing work in the nursing homes as well to earn money, and they have got their own nursing homes as well. We can call it a benami or something like that. So we have to do proper implementation of laws and we have to go for the strict punishment of those doctors so that common man gets the proper treatment properly and medical negligence is removed in that case. Thank you.
Thank you, Dr. Praveen. Next we have with us Mr. Rakesh Gosai, who is visiting faculty with Amity Institute of Advanced Legal Studies. I kindly request Mr. Rakesh Gosai to his views on the topic.
Honorable delegates, members of the dais, it's an interesting topic, medical negligence and law. I would take you to a situation of two extreme settings where a doctor is in a corporate hospital treating a patient, say with a angina, and similarly a doctor in a remote area with very little connectivity and having only very little resources and having the same patient with angina. What would be the course available to him? Answer would be very simple. In a corporate hospital, the doctor would immediately ask for a angiography, all the tests, get a good result and perform a surgery. May or may not be. But in a rural setting, the person may not have even an X-ray or to talk of an angiography. The doctor may not even be a specialist, may not even be a cardiologist. He may be even a CMO, that is a casualty medical officer. Maybe he is sent for a rural job. So therefore, the point which I am trying to bring before you is that first, in any case of medical negligence, we must see the settings in which the doctor and the patient work in. We can't compare the both situations as equanimous or equivalent. The doctor or any professional, whether even including lawyers, nobody wants to tarnish his image. Nobody wants wants to see that his patient loses. Most of us are lawyers, and most of you will agree with me that we as lawyers feel more bad when we lose a case than even our own clients. We are rather more eager to file the appeals and get a stay. Similarly, the doctors are also equally affected by the result of their treatment and their surgeries. In law, we always have an expression, fait accompli. But when we ourselves, we go to the doctors with our own patients, with our own relatives, we refuse to accept the same, fait accompli. I'm not even contending or submitting that doctors do not make a mistake. Everyone can make a mistake, even we can make a mistake, even I can make a mistake. But what we have to see is that mistake such a grave that it can be termed as medical negligence? Whether the same doctor who was treated by the patient as a demigod before the operation, before the surgery, before the treatment is reduced or is taken to the level of a criminal, we file FIRs, we suggest to the clients, please file FIR. The moment a doctor, as my learned friend has said, that there was a wrong, instead of hands, the legs were amputated, or instead of right eye or left was operated, or something like that, those are the cases of res ipsa locator, where doctor is no more a doctor. He has already reduced himself to the level of a criminal. But the doctors, the medical negligence, we are confining only to those doctors who are operating in a particular setting and have given an erroneous judgment, have given an erroneous treatment, a wrong treatment, have delayed in giving a treatment. Being a qualified practitioner, they have not been able to adopt or prescribe the correct course of action. Even amongst us, lawyers, we always think before whether to file a suit against the state or to file a writ petition. Similarly, there is divergence of opinion amongst the medical fraternity also, whether to take a prescription A or to go for prescription B. Like in a case of angina, reversible angina, whether I'll go a bit further, clarify further, whether say it's a blockage of 2 arteries or 3 arteries, whether a person should go for a angioplasty or should go for a bypass. There are varied opinions, and both opinions are valid. Both opinions are valid. Both are working. In both the settings, persons can work. The best example, the recent example, will be Dr. Manmohan Singh, our own Prime Minister. There was a huge debate whether you should go for a angioplasty or you should go for a reverse bypass. The doctors chose bypass. Though angioplasty would have been much easier for them. But seeing the pros and cons, they opted for the bypass. And the patient, the Prime Minister, consented for it. So informed consent also becomes a very relevant factor in medical negligence cases. Today, all of us will agree that the moment we go to a hospital, the doctors, the hospitals give us a complete contract before they touch a patient to sign that, so that in case of any unlikely event of the surgery or treatment going wrong, we may not accuse them. Even then, the cases of which we are saying medical negligence or res ipsa locator would be very easily detectable, can be tried, and doctors are even punished. But the law should not be made so strict that tomorrow, instead of looking at the patient first, the doctor, instead of remembering his Hippocratic oath, he first looks at the contract, whether the contract saves him for touching the patient or not, making a